Workers' compensation insurance protects your employees for injuries during the course and scope of employment, and it protects your business from related lawsuits. Trusted guidance is provided by FloridaWC.com, your partners for workers' comp.
Thanks for joining us. Today we're going to discuss the workers' compensation statute of limitations and the ways that it affects you as an employer within the state of Florida. We're joined today by Michael Rabinowitz. He's a workers' compensation defense attorney with the law firm of Banker, Lopez & Gassler. And Michael's going to give you a couple of tips on ways that this statute of limitation affects your business.
Thanks, Drew. If you saw our last video, you know that the statute of limitation is a ticking clock. It's the amount of time the injured worker has to file a lawsuit in workers' compensation against you, the employer. For the first tip I can give you is make sure you document every accident, because this, quote-unquote, starts the clock. As soon as an accident is documented, we know that an injured worker has 2 years from that date of accident to file their lawsuit, or 1 year from the last date they received benefits, usually medical benefits. Also, when you complete your accident report, make sure you note that you, the employer, offered the injured worker medical attention for their accident or injury. Drew, so many times in my practice I get claims where the employer did offer medical attention to the employee denied it or rejected it, and then months later or years later the employer is surprised that they got a lawsuit. They didn't think an accident took place. It's important that you document this so that when you do get an accident, you can at least say from the statute of limitations point of view that you were there to offer that medical attention to them. Second, it's important that you tell the employee of their rights under the statute of limitation. You'll see a link below us right now to the myfloridacfo.com website for the state of Florida's Department of Financial Services. It's a PDF and a pamphlet that you can give to your workers when they are injured in an accident, and it tells them their rights under the statute. Per Florida law, if you, the employer, don't advise the injured worker of his rights and responsibilities under the statute of limitation, in other words, he has a time period when he has to file his lawsuit, then you could lose the defense of statute of limitations in trial. Finally, if you do have a repetitive trauma claim, in other words, like a carpal tunnel syndrome claim, or a worker that lifts a lot and their back hurts over a period of time, not just from one date of accident, it's important that you get medical records from your injured employee advising them that their current injury is related to repetitive trauma at work. Under the law, the statute of limitations doesn't run until the employee himself is made aware by their doctor that their repetitive trauma injury is work-related.
Thank you. For more videos, check out FloridaWC.com and you'll see some more on there with Michael as well. Thank you for your time.
For more information, visit FloridaWC.com. We are proud to be your trusted choice.